Okay. Hello, everyone. Daniel Herrin, the founder of Herrin Law. And I wanted to do a quick video kind of explaining our philosophy as it relates to the attorney-client relationship and what I believe separates us from other law firms. Almost every person who has had to hire a lawyer, the first thing they usually talk about is the communication. They don't get updates. They don't know what's going on. And from the client perspective, sometimes attorneys can lose uh, empathy or what it's like to be the client. The attorney does this all the time, but for the client, this is a major life event in often situations. And so when you're not giving them proactive updates, um, oftentimes the clients will start to not only have resentment, but they're going to start doubting, like, what's going on? Is everything okay with my case? And it creates a friction between the attorney client relationship, and the attorneys often will say, well, there's no big updates yet, we have to kind of you know uh, when we get something we'll let you know. But just giving someone an update, hey, we're waiting on this 2 weeks, here's what we're doing. But it goes more than that. At the beginning of the case, I believe any attorney, you should have a general case strategy, a blueprint from we're starting here, this is our goal, clarity on this is the outcome we want. Everyone has to have a shared vision of you are paying me money to do this, and everything we do needs to be tailored towards this outcome. Well, oftentimes attorneys won't do that, or maybe they start that way, but then they get into the weeds and they go down rabbit holes. There's all these little things, and everyone loses sight of the core strategy, what we're trying to do. So attorneys end up taking actions that don't move us closer to the outcome we want and end up being a total waste of money, right? Your job as a lawyer is to utilize your client's resources in the most efficient way possible. I want to get from A to B. Now, a good plan will map out, look, if everything goes our way, best case scenario, you make a lot of assumptions and you say these are the assumptions that go our way. Now, that's almost never going to happen, right? But you also have worst case scenario. So what I do with our plans is sort of what I call if then conditional logic. Look, we're going to try this. Depending on how the other side responds, we're going to do one of two things. But by anticipating what the roadblocks are going to be, and I know you can't anticipate everything, but you can anticipate 80%. If you're a good lawyer and you have experience, you know 80% of what's going to happen. And if they do this, here's what we're going to do. But your client understands, right? They see this blueprint. And so as things are unraveling, that blueprint lets them understand the context. But it also helps the lawyer. Do we really want to do this? Do we want to be really aggressive with this motion, get hearing set? It's going to cost us a lot of money to do it. So is it going to lead to the outcome we want? And oftentimes attorneys will spend a lot of money doing, tactically, like on a specific motion or whatever it is, they lose, and it doesn't do anything to further the case. In fact, it hurts the case because they've deployed money on something that really was pointless. And hindsight's always 2020, but the idea is if we're going to do this motion and there's a low probability of us prevailing, right? That's what we're talking about, like 50-50. Um, Even if we don't prevail, is it going to help us in our case strategy? Meaning, is it going to require the other side to give us information so we can be more prepared at trial? That's generally how the process works, and that's how philosophically we handle cases. And that's the type of relationship we want with clients. So that's it. Uh, Thank you.